Hear ye, hear ye, hear ye. The Colorado Court of Appeals is now in session.
Thank you. Please be seated. Good afternoon. Welcome to Division 4 of the Colorado Court of Appeals. My name is Bob Hawthorne. To my right is Judge Ted Tao. To my left is Judge Gail Miller. We will be the judges comprising Division 4 that will ultimately enter a ruling and a decision in the cases before us this afternoon. We have two cases on our docket, on our 1:30 docket, and the first one is People v. Muniz, and the second one is People v. Salgado. So I see that counsel are both experienced appellate counsel. You probably don't have any questions about our practice or procedure here in the court. I'll remind you that the time is self-monitoring for the amount of time that you might want to reserve for rebuttal. And I'll also remind you that we are live streaming our oral arguments. I don't think there's sensitive information in either of the two cases before us this afternoon, but if there is, just keep that in mind. And for those folks in the audience, if you have a phone or any other device that might go off during the proceedings, please make sure those are turned off so they don't interrupt counsel or the court. And with that, we're ready to proceed on People versus Muniz, 2016 CA 1547.
Good afternoon, may it please the court. My name is Rachel Mercer, attorney registration number 47633, and I appear today on behalf of Mr. Jose Muniz, the defendant appellant. This case raises a simple question. Was Mr. Muniz entitled to access to the Crime Victim Compensation Board's records that the prosecution claimed supported its requests for restitution for two items, lost wages and locks and windows, before he could be ordered to pay restitution for these items? This court should find that he was entitled to this access. The facts of this case are that Mr. Muniz was charged with second-degree assault, and he pled guilty to that offense, and the prosecution then requested a little over $23,000 in restitution. Most of this, Mr. Muniz conceded it was payable to the Crime Victim Compensation Board because they paid various expenses to the victim, and Mr. Muniz admitted that he owed a little over $20,000 for medical and dental expenses because he had seen documents in discovery that supported this request, and he knew it was covered by the restitution statute. The only restitution that he disputed were the $2,507 for lost wages and the $364 for locks and windows, because he had not seen any documentation that supported these requests, and so he didn't know if it was covered by the restitution statute. Because he didn't know what the basis was for these requests, he asked the court to review the board's documents in camera and then to give him access to it so he could review them and challenge the motion if necessary. This court should find that Mr. Muniz was entitled to access to these documents under the Crime Victim Compensation Act because it gave him a right to them, and because without access to them, he could not effectively challenge the restitution motion.
Ms. Mercer, let me ask you a question at this point. It appears from the statute that, yes, the defendant may have a right to view some of the documents in the possession of the compensation board, but only under certain circumstances, and that would be through an in-camera proceeding, possibly. And in order to obtain an in-camera review of those records, the statute requires that the defendant present a non-speculative evidentiary hypothesis that warrants that in-camera review. It appears to me that that's the crux of this case, this appeal. What is the non-speculative evidentiary hypothesis that you believe would entitle the defendant to obtain review of those confidential records.
And that is exactly the statute that I believe gave him the right to this, because he did meet that burden under the statute. The not speculative argument that he provided that set out an evidentiary hypothesis that warranted the in-camera review in this case was, first, with regard to the lost wages, he pointed out that there was no evidence in the record that showed that the victim had a job at the time of the crime and that she lost over $2,500 in compensation as a result of the crime.
Wasn't there? If the Crime Victim Compensation Board says you get compensated, victim gets compensated for this, that is a statement under the law that the necessary causation and link exists, right? Because it's presumed to be enough evidence.
Yes, that is,
So if there is that evidence, if there's a statement that the victim would get compensated, that is evidence in the record that the necessary causation and causal links existed, correct?
I would argue that is not evidence in the record that the causal link existed. That raises the presumption, that raises the presumption in the restitution statute that there's a link between that payment and the defendant's conduct. But that presumption can be rebutted, and in this case, Mr. Munoz asked for the opportunity to rebut that presumption.
It has to be rebutted before he gets to look, doesn't it? That's what an evidentiary hypothesis means.
An evidentiary hypothesis is, by definition, an unproven supposition. So Mr. Munoz's hypothesis in this case was, because we haven't seen any evidence that indicates the victim had a job and lost this much compensation, my hypothesis is that they're not going to be able to support this claim with their records, that their records are not going to be sufficient to support this claim. That's my evidentiary hypothesis, my unproven supposition that I would now like to test in an in-camera proceeding. And
But
these
if-
are very, go ahead.
If you're allowed to say it that way, then aren't you allowing piercing the presumption, overcoming the presumption, by saying nothing more than, well, maybe it wasn't?
I think what that allows you to do is to get access to the documents so you can review them and then have a meaningful hearing. It does not yet rebut the presumption. Then once we have the hearing, he can rebut the presumption by saying, okay, I've seen these documents and I see that she actually had a lower paying job than was expected. She didn't miss this much work, or she wasn't actually employed at the time. She was only employed part-time. You know, then you make that argument and you rebut that presumption that was raised in the statute once you have your chance to a hearing. And that's what Mr. Munoz wanted in this case. He wanted his chance to a hearing, his day in court.
He had a hearing, didn't he, counsel?
There was
There-
not.
There was a hearing. It's in the record.
The only hearing in the record is a hearing on the prosecution's motion to quash the subpoena, whereby,
Which sort of morphed into a restitution hearing, and without any objection by defense counsel.
I would argue that it didn't really morph into a restitution hearing. You'll see that that transcript is only 5 pages long. When defense counsel attempted to articulate their objections to the restitution motion, the court said, well, aren't those small items? Aren't those not worth much money? And he said, well, we're still raising an objection. And the court said, well, I'm granting the motion to quash, and since you have no evidence, I'm going to also grant the restitution motion.
Even if you had established your evidentiary hypothesis, you still have to show that the documents are necessary for the defendant to rebut the report from the board, right?
Yes.
There's other evidence out there. Was there any effort by the defendant or defense counsels to contact the victim or to subpoena the victim?
I think that raises a really interesting question. I'm not sure that defense counsel, well, I'm not sure that policy-wise that's a great way to read the statute, such that defense counsel should now be contacting victims and saying, I need to know what the basis of your crime victim compensation application was when the prosecution already has that evidence.
Victims testify all the time in restitution hearings.
They do, that's absolutely true.
So why couldn't she have been subpoenaed?
She,
I mean, there's nothing in the evidence that tells us why she couldn't be subpoenaed, correct?
that
Nothing in the
is
record.
true. But the evidence, the problem was that Mr. Munoz in this case didn't know what he was looking for because he didn't actually know what the claim was
Sure, he knew what
against him.
he could have found it through testimony of the victim. They could have found out did your locks and windows need to be repaired? And why did they need to be repaired? And then she could say, well, I was afraid he was going to come back, and you would be able to disprove that perhaps, I don't know. Or she would say, I was just generally afraid, in which case you'd have an argument to be made. But without that testimony, but that's testimony you could have brought. Similarly, with the wages, you could have said, you could have asked her questions about who she was employed with at the time, and if necessary, you could follow up with that employer. You could ask exactly how much she was making. I mean, it just seems like the defense just sort of sat back and said, it's not our problem, just give us those documents.
I think that if we go that route and we're requiring the defendant to guess at what the prosecution's evidence might be and to then try to rebut it by presenting evidence, to go on an exploratory mission, to guess at what the basis.
What do you mean to guess at what the evidence might be? It's pretty specific what they said were the losses. Windows and locks that were broken and had to be repaired, and lost employment. So I'm not sure what would they have to be guessing at.
Well, for example, with the locks and windows, there's no evidence of property damage, so it'd have to be some kind of ongoing and specific and ongoing threat from Mr. Munoz, which he articulated to the court that he didn't believe he presented any such threat. And I want to make an important point to the court that was not made clear in my briefs, and I apologize for that. But if you look at the minute orders in this case, you'll see that Mr. Munoz was arrested shortly after the crime in this case, just a couple days later, and he has been in custody of either the jail or a prison every day since then. He still remains in custody. So in this case, it's actually not possible for him to have presented an ongoing threat to the victim because he was in custody the entire time.
And that was not presented to the trial court at the time of the hearing, was it?
That would have been evident to the trial court at the time because he showed up for every hearing in custody.
Are you suggesting that individuals who are domestic violence perpetrators don't present indirect risk through others, through confederates, through friends, that by definition she might not have had some fear in that regard?
I think it would be speculation to say that Mr. Munoz was going to get someone else to harm her. There's nothing in the record that suggests that. And in fact, she said at the sentencing hearing that this was an isolated incident, that she wasn't afraid of him. And the district attorney in response said, I don't have any reason to believe this wasn't an isolated incident. So
And she
there's no
probably didn't
evidence
change her
of-
locks, she didn't think it was a problem for that reason. And you could have presented that evidence.
Well, I think that runs right into the due process problem. If you read the statute that way, then what's happening is Mr. Munoz is being sentenced on the basis of evidence that he does not have access to. And the due process law clearly establishes that he has a right to notice of the evidence against him so that he can have a meaningful opportunity to rebut it. And I would urge this court to just resolve this case on the simple statutory interpretation basis that the statute says evidentiary hypothesis. It does not say proof that this restitution is unfounded. It says evidentiary hypothesis and unproven supposition.
But it says not speculative, and I believe you just in response to Judge Miller said he didn't know what was in there. Isn't that by definition speculative?
I think if you read it that way, you read that word speculative in that fashion, and you say that unless you know what's in the records, you can't rebut the presumption, you've created an irrebuttable presumption in prosecution, which also violates due process.
And I disagree in this sense. Here's a very possible scenario in this very situation. As I understand the record, this was a domestic violence setting, so he knew her. They were together in some fashion in an intimate relationship. Why wouldn't he just take the stand and say, we've been together X years and she's never worked a day in her life? There you have evidence, non-speculative, that says the information relied on by the board might have been false. I'd like the judge to look at it. In the absence of saying anything other than, we just don't believe it, Judge, I think you're writing the word speculative right out of the statute, aren't you?
And I think if we read this word speculative in too broad a fashion, we will create a due process problem. But also in this case, he had just been in custody. He'd only been released from custody a couple days before, and she was actually his ex-girlfriend. So there's no evidence that he had that personal knowledge. I want to take a quick minute to distinguish this case from Rivera. And I think Rivera is the case where this statutory language comes from. And I think Rivera is a great example of a speculative request for documentation. In that case, it was undisputed that the defendant had sexually assaulted the victim, that she had received counseling as a result of the sexual assault, and the cost of this counseling was a certain amount. The defendant asked for access to the counseling records because he thought it was possible that she may have also received treatment for some other issues at the same time, and that might reduce the amount of restitution. He had no evidence to support that, and the evidence before the court indicated it was valid restitution, and indicated that even if she was talking about other issues in the counseling sessions, they were also attributable to the defendant's conduct, and so compensable in restitution. In response to that request, this court said, that's too speculative. That's a fishing expedition. Here, Mr. Munoz said, I'm looking at the record. There are gaps in the record that need to be filled in. The restitution statute requires the prosecution to present the evidence. We don't have it. Can I look at the board's records? Because I'm not sure they're going to support this. I have an evidentiary hypothesis that they're not going to support these requests. And I would like, under the due process clause in this statute, the right to review the evidence against me. And so this case is very different than Rivera because he pointed to real identifiable gaps in the evidence before the court and said, we have a problem here. And with that, I'd like to reserve the rest of my time for rebuttal.
Fine.
May it please the court. Elizabeth Ford Milani, registration number 48843 for the people. The people respectfully request that this court affirm the trial court's restitution order. Defendant's contentions, I think, break down into three different claims, and the Henry decision from this court in April resolves two of them. But I want to back up a little bit to talk about crime victim compensation boards. These boards provide protection and assistance to victims. And in order to effectuate that purpose, the CVB statutes set out how and for what a victim can be compensated based on criminal conduct. The CVC board reviews that requests and makes a determination whether the victim will be compensated. And in light of all this work on the front end, the General Assembly has concluded that that work and that determination is entitled to some weight in the form of a rebuttable presumption, and that's in 18-1.3-60310. And the statutory procedure was followed in this case.
So let's just jump right to the concerning aspect. Your opposing counsel said, how can there be due process if the defendant isn't even given access to the information with which he might defend himself?
So due process only requires notice and an opportunity to be heard. Built into the statutes are both notice and an opportunity to be heard. The Crime Victim Compensation Board has to provide a certain amount of information as to what it paid the victim for, so there's notice. And with regard to the opportunity to be heard, as we've talked about, a defendant can get access if there are sufficient thresholds met. A non-speculative evidentiary hypothesis, an in-camera review by the trial court, and the trial court makes a determination whether to release the records. Just because defendant didn't take advantage of those opportunities to be heard and the opportunity to proceed with an in-camera review by meeting the threshold determination under the statute doesn't mean that the statute deprives him of due process or any other defendant in this scenario.
So if the Victims' Compensation Board, either because of a misreading of the statute or frankly, even because of more nefarious motives, says, we'll pay for anything, just come on in and ask for it, we're not going to require any kind of proof, and yet they file a report with the court that becomes a presumption that is fairly difficult to pierce. What's to prevent defendants from being ordered to pay restitution on things that are not part of the crime?
So I think there are already statutory safeguards that require the Crime Victim Compensation Board to only make their determination based on appropriate considerations. If there was some sort of nefarious purpose and those were ignored, perhaps there would be a bigger problem. But in this case, a defendant, notwithstanding that nefarious purpose, a defendant could come forth and make a non-speculative evidentiary hypothesis. For instance, I know the victim has never worked a day in her life, like I believe you said. Therefore, the that could trigger the trial court to conduct that in-camera review in that case. But even looking at the email from the Crime Victim Compensation Board that's in the record, they talk about how all the payouts listed below have been verified, they were approximately caused by the criminal actions of defendant, and only expenses that are eligible by statute for payment are paid. So I think there are these built-in.
Isn't that boilerplate language that probably appears in every order issued by that board?
I'm not sure
It
that that
looked
means.
like it to me.
Sure. Maybe it appears in every single email that they send out, but that doesn't mean that the Crime Victims Compensation Board isn't following that procedure on every
I don't
time.
mean to impugn their integrity, but
Sure.
how do you, just knowing that there are rules they're supposed to require doesn't mean that they comply with the rules. I mean, we wouldn't need courts if everybody complied with the rules.
Certainly.
And in addition to that, isn't it hearsay?
I think that the hearsay problem isn't as pertinent here in this proceeding with regard to restitution.
Well, let me ask you this. You mentioned the Henry case, and it kind of my question dovetails with what Judge Miller is just asking about. In the Henry case, there was a witness from the Crime Victim Compensation Board who testified, and actually testified to those things that are contained in the boilerplate report. In this case, there's not. And my question is, can the prosecution, when it asks for restitution, rely solely on the report from the board, as it did in this instance? Can it do that in every case in which the Victim Compensation Board has made payments to the victim?
I see no reason under Henry why it cannot. In fact, if looking at the testimony from the witness in Henry, they didn't even provide particularly specific information with regard to that victim in that case. They sort of talked about their procedures, which are outlined by statute, and said that they had no reason to believe those procedures weren't followed. But I don't read anything in Henry as requiring some sort of in-person witness. And to the extent that this information, that the Crime Victims Compensation Board followed these procedures, was in the record, therefore, there was adequate safeguards of reliability. The trial court could rely on those determinations from the CVCB. And because the Crime Victim Compensation Board said that it paid out to the victim these amounts and that it followed the statutes and procedures in doing so, that determination became a rebuttable presumption under 60310. And as Henry points out, that tied the criminal conduct and the payment together, such that defendant would have had to present other contrary evidence, which he did not in this case at the restitution hearing.
Well, let me follow up on my question. I'm just bothered by the thought that in restitution proceedings or requests for restitution by the people, that in any case where the Crime Victim Compensation Board has made payments to the victim, the prosecution can say, here's the report from the board, we're done.
I think this is exactly what's laid
That's-
out.
That's our burden of proof. We've carried our burden of proof. There it is, no witnesses, no documents, nothing except, well, I can't say no documents. The report from the board, that's it.
I think that's exactly what has been envisioned by the General Assembly by these statutes. That is the procedure. And not every restitution case goes through a Crime Victim Compensation Board, so it's not as if this is always in every single case.
Sure.
But I think that the General Assembly has concluded that that is the proper process. And by creating the rebuttable presumption, I think that that's exactly what the legislature intended. But there are these methods for a defendant to have appropriate notice. They just weren't met in this case. And I would like to talk a moment about lost weight.
Could I just ask a question? So in this case, are you suggesting that if the defendant had testified at the hearing, I was there was no damage, yes, I shoved her out the door, but the door was open, there was no damage to any windows or locks, and we'd been talking, and I've talked to her since then, and she's told me that she wasn't actually working then. That would be sufficient to raise to get access to the documents? Would that be a sufficient evidentiary hypothesis?
I'm not even sure if that would have had to be testified to. So for instance, defendant filed an objection to the restitution request in this case. I think that those assertions perhaps could have been included in there, that I know that the victim doesn't have a job. I know that I didn't damage anything, and I haven't contacted her since. None of my family has contacted her. I think those would have been sufficient non-speculative evidentiary hypotheses to trigger an in-camera review. But asserting that the record didn't contain this information was not a non-speculative hypothesis as to anything. It just asserted that the record didn't contain it.
Well, is there a difference between the lost wages and the locks? Because, first of all, let me start with the premise. The locks on the doors, if they're solely as a future safety measure, is that a pecuniary loss that is capable to be, of being ordered in restitution?
Under the CVCB statutes and under case law, yes.
Okay, is there a difference between what the compensation board can reimburse for and what the defendant can be ordered to pay? In other words, is everything that is subject to the board's discretion to pay, to reimburse a victim for, is everything in that category also a pecuniary loss for purposes of restitution?
I think so, and I think that that has come out of the case law. And why I say that is, so there's the Martinez case in Trujillo, and that line of cases that talk about if there is a specific ongoing threat to the victim, property or payments made to change property can be paid in restitution. Now, that particular expense is not set out necessarily in the restitution statute, but it is compensable as restitution. That type of expense is specifically set out in the CVCB statutes, property changes to ensure the victim's safety. So in that way, they mirror each other.
So if, in the hearing that we had, the attorney or the defendant says, I didn't damage anything, the police reports in your file don't show that I damaged anything, and I'm locked up, isn't that a sufficient non-speculative evidentiary hypothesis that any lock change would be not related to this because it couldn't have been for the safety?
I think, as you pointed out beforehand, Judge, that this could be a specific ongoing threat. What about the defendant's family or friends? I think that there still could, as a result of this conduct.
But all we're talking right now about is opening the door to the in-camera proceeding. Is it a non-speculative evidentiary hypothesis to say, given the fact that nothing in your file suggests that any lock was damaged or window was damaged, and I'm locked up, isn't that a sufficient non-speculative evidentiary hypothesis that there's something that needs to be looked at about whether these locks were necessary or not?
Perhaps, but I would point out that that doesn't foreclose an appropriate compensable payment for the reasons we've talked about, because there could be a specific ongoing threat from someone else, and that doesn't foreclose that. But I do think probably had that assertion been made, and there were 4 days between the criminal conduct in this case and the arrest. The CVCB could have made its determination based on that time. It could have been based on threats from someone else in the family. All that matters is that non-speculative evidentiary hypothesis was not met. And with regard to lost wages, defendant raises this as also a claim in regard to the briefs. That he did not challenge lost wages in his objection, and the very bare reference to it didn't raise any sort of non-speculative evidentiary hypothesis that I know the victim isn't working, for instance. Counsel said, I believe the verification would probably be in the victim's compensation records. Just verification and lost wages were for a job that perhaps already existed, and they are in fact verifiable lost wages. I don't think that assertion at the restitution hearing was sufficient to trigger an in-camera review with regard to the lost wages.
Well, Counsel, Ms. Mercer, I believe, is now contending, I don't recall that it was in the briefing, but that this wasn't a restitution hearing, that it started out as a hearing on the people's request to quash a subpoena, and it sort of morphed quickly into some form of a restitution hearing. What's your response to that? Does this really constitute a restitution hearing at which the defendant had an adequate opportunity to present evidence contradicting the board's figures or totals?
Sure, I guess I'll answer that in 2 parts. First, I do think this was a restitution hearing because the trial court ordered restitution at its conclusion. That's what they were talking about. That was the purpose of this hearing. And defendant made no record below that wait a minute, Judge, I've got people in the hallway waiting to testify. Let's do this evidentiary hearing. That never happened. They discussed the fact that the non-speculative evidentiary hypothesis had not been met. And while the trial court didn't state the statute by name, I think that it's clear reading the transcript that the trial court was relying on 60310 and that the prosecution had met its burden. And perhaps not in the record, but let me say that again. There was no indication that the defendant had any other evidence to offer. So I think that this absolutely was a restitution hearing, and the trial court followed the statutory procedures that have been set out. Like I said, to the extent that this court takes up the constitutionality of this sort of statutory scheme between the rebuttable presumption as well as the confidentiality statute in Title 24, I think that they certainly pass constitutional muster. There was notice, there was an opportunity to be heard. Just that defendant didn't take advantage of those opportunities in this case did not doom the constitutionality of these statutes.
Can I ask you a question? You filed a supplemental authority on the Barber case. Does that change the standard for review in this case?
Well, I think with regard to the sufficiency of the evidence, that division has applied a de novo review in terms of whether the rebuttable presumption created sufficient evidence to prove the restitution amount. I haven't seen another court apply that standard, and in the Henry case, there was an abuse of discretion. So I think there is a statute.
There was a decision on Ortiz before Barber, which I think also said in a sufficiency of the evidence case, you applied a de novo standard.
As I remember Ortiz, there was a statutory interpretation question in there
Maybe
with
that
regard to sufficiency of the
that
evidence
must be
about who can be a victim or something in that regard. I think under either standard, the evidence was sufficient. It seems to be an open question, how to review restitution orders, but I think under either standard, the evidence was sufficient. If there are no further questions I can answer, the people respectfully request that this court affirm the restitution order.
I just wanted to start by saying that the hearing was clearly labeled a return on the subpoena ducis tecum. That's the first thing that defense counsel says to the court. We're here for a return on a subpoena at that hearing. So there was no notice that was going to become the one and only restitution hearing in this case. Also, it is important to note in response to your question, Judge Tao, that they are applying different standards in the Crime Victim Compensation Board hearings than they do not apply the restitution statute. They apply the Crime Victim Compensation Act, which is explained in the briefs. And that has different standards. For example, it does not require evidence of a specific and ongoing threat to the victim in order to have security paid for. It simply requires them to feel that it was necessary for their security. It's a different standard. And in fact, the board's summary in the record on court file page 71 says that they are applying the Crime Victim Compensation Act, not the restitution statute. And we did say, defense counsel did say that they did not know of any property damage and that Mr. Munoz did not think that he presented any ongoing threat to the victim. That should have been enough. If that was not enough to trigger an in-camera review, it's hard to imagine what is. The legislature cannot bypass due process. And so Mr. Munoz would ask this court to vacate the challenged portions of the restitution order.
Very quickly, where in the record did the constitutional due process claim get preserved?
In the written objection to the initial motion for restitution, we explained that without access to the documents, we would not have an ability to challenge the restitution motion, and we said this motion is made pursuant to the due process clauses of both the state and federal constitution.
Just the listing of all the provisions. No developed argument, though.
There was developed argument, as quoted in the brief, in the reply brief. They said we will be unable to challenge it. That's clearly the spirit of a due process argument, and then they say expressly we're making this objection pursuant to the due process clause.
Was that then raised in the subsequent hearing?
That was not specifically discussed in the subsequent hearing, which was very brief, but the written objection should have been enough to preserve it, even though the court chose not to.
Did the court at the hearing rule on that argument?
The court did not give defense counsel, I think if you read the transcript, much time to talk at all at the hearing.
You keep saying if we did. Yes, we read the record.
Well, I think if you look again at that particular, with that in mind, you'll
Yes.
see that they.
Well, neither did counsel object. It seems like counsel, if counsel thought this was solely a hearing on the motion to quash that had morphed, I keep saying that, morphed into a restitution hearing. Counsel never did say anything about that. Counsel never said, whoa, wait a minute, Judge. I thought we were here on a motion to quash subpoena. Now we're talking about restitution. I'm not prepared. I need to call witnesses. I need to do something. Counsel just went along with it.
Well, I think everything just happened very quickly, and I think that the written objection was still in the record and was something the court needed to address, and that the court chose not to address it. But that doesn't mean that the issue wasn't raised and it wasn't given an opportunity to do so, which is what defense counsel clearly intended to do with that written objection.
Okay, thank you.
Thank you.
Thank you, counsel, for your arguments. Those will be helpful to the division in reaching a decision in this case. The matter will now stand submitted, and a written opinion will issue in due course. Thank you again. Counsel are excused, and counsel for the next case can set up as soon as the tables are vacated. Next case on our docket is People versus Salgado, and that's 2018 CA 885. Welcome to Division 4, Counsel. And unless you have any, I know you're both experienced appellate counsel, so I don't imagine you have questions about our practice and procedure here. If you do, please express them now. No? Okay. With that, I'll just remind anyone who's come in to the courtroom after the last argument, if you have a telephone or anything else that might go off during the proceedings, please make sure they're turned off so that doesn't interrupt counsel during their argument. With that, we're ready to proceed on People versus Salgado.
Good afternoon, Your Honor. My name is Glenn Roper, registration number 38723. I'm the Deputy Solicitor General of Colorado. With me at counsel table is Jacqueline Fredericks, Senior Assistant Attorney General. May it please the Court, Colorado's Medicaid Fraud Control Unit is a team of exceptional attorneys and investigators. Since 1978, the unit has investigated and prosecuted thousands of Medicaid provider fraud and patient abuse and neglect claims under the authority of executive orders issued by the governor. In this case, a district court for the first time dismissed a prosecution on the ground that the latest executive order, order number 1787, was valid when issued, but expired after the issuing governor's term ended. On appeal, no one defends that holding. Instead, Ms. Salgado argues that Order 1787 was unconstitutional from the outset because the governor improperly exercised legislative authority in issuing the order. This court should reject that argument and reverse the district court because Order 1787 is an appropriate use of the statutory authority given to the governor. It was valid when issued, and it remains valid today.
Can I ask just a preliminary question? The parties seem to treat this as a motion of jurisdiction in the trial court, but I take it no one is today, at least you're not arguing that the court, well, certainly you wouldn't argue, but no one's arguing that the court lacked jurisdiction. Is that correct?
I think that's right. I don't view this
I'll ask
as a jurisdictional question, but simply as to whether the Attorney General had the authority to initiate the prosecution. And the controlling statute is Section 2431-101, which directs the Attorney General to prosecute and defend all actions and proceedings, civil and criminal, in which the state is a party or is interested when required to do so by the governor. Nothing in that statute places any geographic, time, or subject matter restrictions on the cases that the governor can require the Attorney General to handle. It grants broad authority. Now, that isn't to say that there are no limits on the governor's authority in this area. I think there are at least 3 sources that provide appropriate limits. First, the statute itself requires that the state be a party or be interested, and the governor cannot direct the attorney general to get involved outside those parameters.
But that would be every criminal case, correct?
It would, yes. Second, the state and federal constitutions provide restrictions within which the governor must operate. And then third, and perhaps most importantly, the General Assembly can statutorily alter or restrict the governor's direction to the attorney general. Now, Executive Order 1787 does not violate any of those limits. To the contrary, the legislature has repeatedly approved of the Medicaid Fraud Control Unit by consistently appropriating funds for its operations and by requiring annual reports of its activities. As I read the answer brief, I don't see anywhere where Ms. Salgado has identified a single case or a single statute that limits the governor's ability to require the attorney general to prosecute Medicaid-related cases. Now, the decisions in People versus Gibson, in Witcher versus District Court, and in Colorado versus Asarco actually affirmed the validity of Section 2431-101 and confirmed the authority of the attorney general to bring prosecutions when directed to do so by the governor.
Would anything stop a governor from, for whatever reason, tasking his or her attorney general with prosecuting every felony in the state?
I think what you need to look at, and certainly that's an extreme example well beyond what we have here, but I think what you need to look at is whether tasking the attorney general with taking over entirely the duties of the district attorney would go beyond the intent of the legislature in enacting this statute, giving the governor that ability.
Is there anything in the language that says that?
Not in the language directly, but I think if, for example, the governor were to parrot the language of the statutes governing the role of the district attorney and saying, I'm going to direct the attorney general to do this instead, I think that would raise significant questions. Again, that's well beyond what we have here.
What if, let's give it a little more flesh to the bones. As in other states, there is often a very political potentiality in terms of the conflict between a particular elected DA and a particular attorney general or governor. What would stop a governor, under your reading, from assigning the attorney general to essentially take over from a statewide perspective as opposed to the local perspective, all of the prosecutions in a district where the elected DA was of a different party?
I think if it does not conflict with the statute and if there are not constitutional restrictions, I think then it would be up to the General Assembly to decide whether to restrict the governor in that manner. But again, if you have something that would conflict with the constitutional office of the district attorney to that full extent, I think you very well may have problems with that kind of an order.
You said unless there were constitutional restrictions. Are there constitutional restrictions? Isn't that part of our issue here?
There are constitutional restrictions for sure. I was referring to something like maybe an equal protection claim.
I see.
Or something where, if, for example, the governor directed the attorney general to target a particular racial group or something along those lines. I would also point out that Order 1787 is consistent with the historical practice in executive orders, and we cite a few of these in our brief. I would particularly call the court's attention to Order 6388, where the governor directed the attorney general to prosecute criminal violations of the state tax laws. And that order remains the basis today for the prosecution of tax crimes statewide. As another example, in 2011, when the 7th Judicial District Attorney resigned, the governor directed the Attorney General's office to handle all criminal prosecutions in that district until his successor, the next governor, could appoint a replacement. And I would distinguish that from the situation where you have an acting, functioning district attorney.
So aren't you running the risk of basically saying that's the way we've always done it as a defense to a constitutional claim?
I don't think, I'm certainly not stating it that way, but I think it's important to look at the historical practice. Executive orders are presumed to be constitutional, and the fact that the governor and the attorney general have both treated that power within this way, and more importantly, the General Assembly has done nothing to interfere or take back from this authority, either in the tax scenario or in the Medicaid fraud scenario, and in fact we know is well aware of the unit's function and operation. I also think it's significant that Order 1787 doesn't bear the traditional hallmarks of legislation. It doesn't establish or alter the law or public policy, and although it directs the Attorney General to prosecute Medicaid-related crimes, it doesn't define what those crimes are or alter the elements of a crime, for example. And the same is true as to civil cases. The order doesn't affect the grounds on which those cases could be brought. Rather than legislative authority, the governor's exercise of the power to direct prosecution is a quintessentially executive function. It's also consistent with the constitutional direction to the governor to take care that the laws be faithfully executed. Now, Ms. Salgado argues that the lack of a spatial or temporal restriction in Order 1787 somehow turns it into legislation. She doesn't cite any specific authority for that argument, and I think it's important to keep in mind the context here, which makes the statewide scope and the lack of a termination date really make sense with this kind of order. We're dealing with a discrete type of case that is directly related to a federal funding requirement that Medicaid-related actions be run out of an office with statewide prosecutorial authority. The district attorney's offices can't qualify for that, and the Office of the Attorney General is the most appropriate, and I would argue the only appropriate entity to be tasked with handling those prosecutions.
The history of the life of the Medicaid fraud unit, it found a home in different entities than the AG, is that correct?
That's correct. Initially, it was a standalone entity. It spent a little bit of time in the CBI, but then since at least 1987, in fact, I think even the order prior to that, it's been in the Attorney General's office.
And in fact, the difference between the 1987 order and its predecessor, the primary difference appears to me to be that Governor Romer removed the obligation of the Attorney General to cooperate with the local DA, didn't he? And if so, is that problematic?
I would turn it around and say that it explicitly allowed the Attorney General to bring cases in his own name. I think that was the most significant change from the prior orders. I don't think at all that's problematic, and think that, in fact, I think that was envisioned by the statute. And I would point out that the Attorney General does consider it appropriate and necessary, in fact, to cooperate with the district attorney's offices. And that happens in every case, including in this case. There was extensive back and forth and discussion about the case, although ultimately the Attorney General was the one who decided to bring it. I would also point out there are at least 3 significant problems that would come from affirming the district court's dismissal here. First, it would call into question everything that the Medicaid Fraud Control Unit has done over the years, including the validity of criminal convictions and the millions of dollars in recoveries in both civil and criminal cases that have been brought by the unit.
Wouldn't that depend on whether or not, excuse me for interrupting, but wouldn't that depend on whether or not they had complied with the procedures that the defendant is suggesting, which is simply to have the people appointed as special district attorneys? And I think they, according to Mr. Weir, that's the way it's always been done in the first district and perhaps in other districts as well. So it wouldn't be quite that sweeping, would it?
Well, I don't think either the district court's order or Ms. Salgado's argument rests on whether the Attorney General is operating as a special deputy district attorney or not. I think Ms. Salgado's argument is that this order allowing the Attorney General to bring these cases at all, whether in her own name or as special deputy district attorney, was invalid from the outset. Now, I think there are defenses that could be made, but I think it raises the issue.
Okay.
If we were to decide that in fact there is some spatial or temporal limitation, or that, as one reading of the original order would suggest, that the executive order dissipates upon the end of that governor's term, we really can't consider whether billions of dollars would be in the balance, can we? If it overstepped his authority, it overstepped his authority. We can't make that monetary judgment, can we?
That may be correct, but I think that it is important for this court to be aware of what's at stake in evaluating the claims that are made here. And in addition to the operation of the Medicaid Fraud Control Unit, I should also point out that the district court's dismissal calls into question the prosecution of tax crimes over the years, which again are done on the basis of an executive order issued in the 1980s that had a statewide scope and no termination date. And then finally, the district court's dismissal could raise questions about whether Colorado was entitled to billions of dollars in federal Medicaid funding that it has received from the federal government, since a prerequisite for receiving those funds is the maintenance and operation of a qualifying Medicaid fraud control unit.
Should there be any concern with the fact that, as far as I can tell, there is no easily accessible copy of some of these executive orders? There's no easily traceable history to know whether, if I find one in the archives, for example, whether it has been superseded or repealed or extended or modified. The tracing of what the law is in this area seems to be rather inconsistent with being a nation of published public laws.
And again, I don't think that the governor's order in this instance is changing the law. It's simply directing the prosecution here. There may be concerns, and I think it'd be a good idea to have these readily available. I'm not sure how accessible this particular order is. If there are no further questions, I'd like to reserve the remainder of my time for rebuttal.
Thank you, counsel.
Good afternoon. May it please the court, I'm Anthony Noble, registration number 33910, and I represent the appellee, Jasmine Salgado. I'd first like to address the Solicitor General's and the Attorney General's argument that if the court affirms the district court, then this is going to affect thousands of cases, thousands of convictions, hundreds of millions of dollars that were recovered in those criminal cases, and billions of dollars in Medicaid funding. There aren't thousands of cases, there are 6. There is this case and the 2 related cases. There are 2 other cases in another facility that were brought in Jefferson County, and then there was 1 case in 2017.
Why would it not reach all the way back to the end of Governor Romer's term?
Because what the Attorney General is trying to argue is that it relied on this executive order in those thousands of cases over 30 years, but it didn't. What it was doing in the other cases is it was following the statutes. The Attorney General was being appointed as a special deputy district attorney and pursuing the cases in that way.
How do we know that? There's nothing in the record that tells us that.
Yes, it's in the record. In the district attorney's notice on jurisdictional issues, the district attorney goes through the history of how these cases have been prosecuted.
He said to the best of his knowledge with regard to the first judicial district. I don't think he talked about other districts.
Oh, the district attorney did talk about conferring with other district attorneys and couldn't find any examples of the Attorney General pursuing under this executive order and exercising this independent authority over the district attorney's authority in that judicial district.
Where's the statutory or constitutional authority for the DA to deputize the Attorney General?
That's in I think it's in section 21102, which gives the district attorney the authority to prosecute all violations of law in that judicial district. And then in section 2431.101.1a, that gives the Attorney General authority pursuant to the governor's executive order.
Right, so
So-
the gist of what you're saying, as I'm hearing it, is to the extent this executive order, well, what I'm hearing you say is that either the district attorney himself or herself has the authority to deputize the Attorney General, which I submit to you there is no authority for in statute or constitution, or the district attorney, once the governor has directed the Attorney General to get involved, can institute a situation where they are appointed as a special district attorney. Is the second one what you're saying?
So the statute is section 21201, subsection 1C, and that gives the district attorney in every judicial district the authority to appoint such special deputy district attorneys as he deems necessary. And then when you go through that paragraph, it includes the Attorney General as one of the parties that it can deputize as a special deputy district attorney.
Could you recite the statute for me?
Yes, 21201, and then subsection 1C. So that's how the Attorney General has been proceeding in these Medicaid cases for the past 30 years. It has not solely relied on the executive order. It's only recently in these 6 cases that it has relied on Executive Order 1787. And the other thing that the district attorney says, it explains the motivation for doing this. There was a review by the Office of Inspector General in which it criticized the Attorney General's office for not prosecuting enough Medicaid cases. So in response to that, the Attorney General found these cases. The DA didn't want to prosecute these cases because they said that there was insufficient evidence and they couldn't ethically prosecute these cases. But the Attorney General, with the motivation of increasing the number of Medicaid prosecutions, latched onto these cases and for the first time proceeded prosecuting the cases without the consent or the authority of the district attorney. So that's how this arose in these 6 cases.
So from what you've been saying, my understanding is your only problem with what's happened is that the only problem with that executive order is that the Attorney General could appear without going through the district attorney.
That's correct, because if you construe the executive order to require the Attorney General to get the approval of the district attorney, I don't think there's any constitutional problem with that. There's no violation of the separation of powers. And one of the other things that the district attorney argued in the district court was that this is the way that the Attorney General is construing this executive order to give them independent authority to prosecute cases in the district attorney's judicial district.
Isn't that exactly what it says?
No.
Shall prosecute in his own name?
Well, it's ambiguous because it's referring to civil cases and criminal cases. So the constitutional interpretation of this executive order is to construe it as giving the Attorney General the independent authority to prosecute civil cases. But if the Attorney General wants to prosecute criminal cases, then it has to be appointed as a special deputy district attorney. So I think that that's the constitutional interpretation of this executive order. And if that's the way that it's interpreted, then there's no separation of powers violation. It's only when the executive order is interpreted to give the Attorney General independent authority to prosecute cases in the district attorney's judicial district, that there are separation of powers issues.
Right, you keep saying separation of powers. They're both executive function.
Well,
Separation of powers is between legislative and executive and
Yeah.
judicial, not between state and local.
Yes. So when you look at the governor's executive power, the governor cannot legislate. Only the General Assembly can legislate.
But the legislature has given the governor the authority to tell the AG to go in and prosecute.
But it hasn't given the governor the authority to issue such broad executive orders that...
What limits it?
Sorry?
Where's the limitation?
In the statutes, the General Assembly has enacted statutes, one of them being the fact that the district attorney has the authority to prosecute criminal cases in his judicial district.
And the Attorney General has the authority to prosecute cases statewide, subject to the order of the governor.
No. So the Attorney General's power comes from the General Assembly. Now, the governor does have some limited power to issue executive orders that give the Attorney General authority to prosecute certain cases. And what we've seen is, I think there are 3 cases...
Where does it say certain cases in the language?
Well, it doesn't, but you have to look at the case law to determine, the scope of an executive order. And the executive orders given the Attorney General approval to prosecute cases in the past have been limited in either time or geographical...
But none of those cases said that that's the maximum limit you can go. They were just saying, in that particular case, it fit within the fit within the statutory scheme.
Yeah, and that proves my point, is they have to come up with authority. I don't have to show
Well, they
you
can
where
go,
they get the
their authority
authority
is the
from.
statute. You've come up with some cases where there have been much more limited ones, and the courts have said that's okay. That
Yeah.
doesn't mean anything else is not okay.
No, but the court has never approved one that's this broad.
Okay? But we could.
Yeah, you could.
I'm not saying we will, but I mean,
No, but I think
just
if you
because it hasn't
do,
happened yet doesn't mean it can't.
no, but if you do, then you're running into problems of interpreting this executive order in a way that makes it legislation, because it encroaches on the General Assembly
What are the
statutes.
specific, what are the specific things we look at to determine the line between legislation and executive powers? Legislative powers and executive power.
Your Honor, I think you have to look at the scope of the power that's given to the Attorney General. So the examples that have been approved by the courts have been very limited in either geography or specific events or a specific time. But this is an executive order that the Attorney General is now claiming has given them authority over more than 30 years and statewide.
So the only limits you're pointing to are the limits in those, in the Witcher case and this federal district court case and Gibson, right?
Well, they're not really limits because, you know, they're examples of
No, they're not
executive
limits.
orders
That's my
that
point.
have been approved. The limit is really in the statute because the problem with construing this executive order to give the Attorney General such broad authority is it encroaches on the General Assembly's exercise of enacting legislation.
Why? The legislature has said in their words, you know, you're adding in as long as there's a temporal and spatial component. But the words of the statute say the Attorney General can prosecute as directed by the governor. Right?
Yes.
So the legislature has acted. The legislature has given the governor the authority to say, Attorney General, go in there and do it. The governor has so acted. Is it your position, for example, that when Governor Romer issued this, it would have been appropriately executive and not legislative if it had said, for the next 5 years?
Well, you know, first to correct the Solicitor General's argument, we're not taking the position that when this executive order was issued that it was unconstitutional. It's only the way that it's being treated 30 years later in this case that it's unconstitutional, given the interpretation that the Attorney General has given it.
So answer my question. Is it your position, I'll take it one step back, is it your position that as it's written, it was appropriate at the time it was written?
I don't think there's anything inappropriate at the time that it was written, considering that, for instance, as the district court said, the governor, you know, would have the power to issue this kind of executive order as like a stopgap until the General Assembly issues a statute that says specifically the Attorney General has this authority.
Couldn't the General Assembly have written in Title 24 that the AG could prosecute, had statewide authority to prosecute as directed by the governor, provided that any such direction shall expire at the end of the governor's term, or provided that any such direction shall expire at the end of the next legislative term so that they have time to step into the gap? But they didn't say any of that.
Or they could have said, provided that the Attorney General appears as a special district attorney appointed by the district attorney.
But they've said that in the statutes.
Where?
In section,
Well, if you have, I know,
Nothing in Title 24 says subject to 20-1-201, right?
no, but the problem is that the General Assembly cannot give the governor power to legislate and encroach on its statutes. The
And that
statutes-
gets me back to my question. So at the time he wrote this in 1987, is your position that Governor Romer was not legislating, he was executing?
That's correct, yes.
But it becomes legislation simply because the legislature doesn't act for 30 years.
Well, no, it really becomes legislation because of the way the Attorney General is interpreting this to give them the independent authority to act in these cases.
The order gave him the independent authority.
Well,
What
that's
you're
one-
saying is only if that independent authority lasts too long in your, my, or some random judge's mind.
Well, that was the district court's ruling. And yes, I'm defending the district court's ruling is that if an executive order, you know, is still in effect 30 years later, then it brings into question whether or not it's an executive order or whether it's legislation. I think the real issue here, though, is that it does give the Attorney General authority, but when you try and interpret this in a constitutional manner, then you cannot interpret it to give the Attorney General independent authority to prosecute cases in the District Attorney's Judicial District. And that's why the executive order refers to either prosecuting cases in his own name or in the capacity as a special deputy district attorney. So because this executive order covers both civil cases and criminal cases, the way to constitutionally interpret it is that in civil cases, the Attorney General has the independent authority. But in criminal cases, that's when the Attorney General has to consult with the Deputy District Attorney. And then when you look at the new statute that's coming in effect in January, that's exactly what the General Assembly has done. It's first given the Attorney General to, requires the Attorney General to consult with the District Attorney in the Judicial District. And if the District Attorney consents to the filing of the charges, then the District Attorney will be appointed as a Special Attorney General. But if the District Attorney does not consent to the filing of the charges, then the Attorney General can independently file the charges.
But they didn't make that statute retroactive, correct, to prosecutions that had already commenced?
I think that's what the Attorney General and the Solicitor General are arguing. Otherwise, this whole appeal would be moot. If we've got this statute that comes in effect in January, then this appeal would be moot because whatever you do here, they could refile the charges in January and continue.
And why can't they?
Well, ask them.
My point is, if your concern is that the legislature's toes have been stepped on, that their world has been invaded by this act that you acknowledge was executive when it was done, they could have said, when passing this new statute, and oh, by the way, we're going to deputize them, or they could have specifically said, and any prosecutions currently ongoing are void. They didn't say either, did they?
So it's not retroactive.
So they're letting the Medicaid fraud care unit as enacted by the executive order stand, are they not?
But the Medicaid fraud unit was created by a prior executive order. This legislation doesn't completely codify the executive order. It creates a different system, a slightly different system. And with that, I'd ask you to affirm the district court's order. Thank you.
Thank you, counsel.
I'd like to make 3 quick points, if I may. First, as to the reliance point, Colorado's Medicaid fraud control unit would not exist but for this series of executive orders. So if they are unconstitutional, then it does call into question everything the unit has done. Second, as to whether we could refile after January 1st, assuming that we're within the statute of limitations, I think that would be an option. Our point is that we feel like we should not have to because we're acting under authority of the executive order. And then finally, as I hear Mr. Noble, it seems like he's changed his argument to no longer be arguing that the problem was the lack of a temporal and spatial restriction, but that it allows the Attorney General to act in her own name rather than as a special deputy district attorney. That's been a feature of Order 1787 from the outset, and I think Mr. Noble conceded today that it was okay at that time. I don't know what would have changed.
I think he was saying it was okay, but he's got his interpretation that that doesn't apply to civil cases in order to maintain the constitutionality of the order.
And I think there's nothing in the language of the order or in the statute that would lead to that interpretation. I think it was clear what the governor was authorizing the Attorney General to do, and this case is an appropriate exercise of that prosecutorial authority. Whether it's a deputy or a district attorney or an attorney general doing the prosecution, that is an executive function, and there was nothing improper about that in this case. And we would respectfully ask the court to reverse and remand. Thank you.
Thank you, counsel. And the division thanks both counsel for your excellent arguments, and those arguments are going to be very helpful to the division in reaching a decision in this case. And the matter will now stand submitted, and a written opinion will issue in due course. Thank you very much again for your arguments. The court will now be in recess, stand in recess, and the bailiff may so announce. Thank you.